Great, thank
This
you.
meeting is being recorded.
Excellent, thanks. Good morning, good afternoon, good evening, wherever you are in the world. Thank you for joining us for our monthly Global Chamber Export Import Forum. Let me have Demetrius say hello. Demetrius, unmute yourself because I want you to be on the screen there.
Yes.
Otherwise, Jem will be there. There you go. Okay, perfect.
Hello.
Okay,
Hi,
back to
everybody.
what I was saying. Okay, perfect. Stay right there. I am the moderator, Anita Rodal, president of SBPI Services Incorporated. SBPI Services helps importers, global companies, and real estate investors save money and time and mitigate risk on their cross-border payments. We also broker business and equipment loans and offer pronunciation coaching for business professionals wanting to speak in more accent-neutral American English. Now, for anyone who is not familiar with the Global Chamber, it is a growing collaborative community of CEOs, executives, and business leaders in over 525 metro regions around the world. Its mission is to foster growth in cross-border business in every region of the world. Our forum today is about 55 minutes long, slightly less because we're starting a little late. The last 5 to 10 minutes, I'll open it up for Q&A. So until then, please keep yourselves on mute. But I do invite you to put your information in the chat. Please include your full name and your LinkedIn link. If you don't put your full name and your LinkedIn link, it's very hard for people to find you afterwards, and we're all here to network, so please make it easier for people to find you, okay? And don't forget to save the chat afterwards. So today we are very, very lucky to have the wonderful Demetrius Evans with us as our interviewee. I will tell you a little bit about her. Attorney Demetrius Evans is the founder and principal of the Evans International Law Firms, LLC, otherwise known as Teal Firms. It's a Chicago-based woman and minority-owned firm nationally recognized for delivering strategic legal solutions in international trade, corporate compliance, and international property law. For more than 16 years, Demetrius, through Teal Firms, has advised companies across the U.S., Africa, Europe, the Middle East, and Asia, helping them expand globally while protecting their innovations and brands. Her focus is on structuring cross-border transactions, navigating import-export regulations, drafting international contracts, and protecting international property portfolios in multiple jurisdictions. She also advises on compliance with U.S. federal trade laws, GDPR, we'll ask about that later, and global data privacy standards. Demetrius is an active member of the Illinois District Export Council, the African Global Chamber of Commerce, she's a secretary, and the Global Chamber Chicago, she's on the advisory board. She frequently speaks on international trade and intellectual property topics, a unique approach that blends the legacy of African trade history, modern business strategy, and forward-thinking legal insights. Demetrius is also deeply engaged in nonprofit and community work, leading I'm having a hard time today. Leading initiatives that connect African and African American communities for economic and cultural advancement, and serving as a commissioner for environmental sustainability in Westchester, Illinois. And to that I say, yay! Demetrius's mission is simple: to empower businesses with the legal tools they need to trade, grow, and compete successfully on the global stage. So I always start off my interviews with 3 very quick icebreaker questions. Think of it as like speed dating. So in 60 seconds or less, here's the first question. Tell us how you got into this business. And from now on, you can keep yourself off mute.
Oh, how did I get into international trade?
Yes.
I think that this is like I get into everything by my curiosity. And so I did go to law school, obviously, and realized that would be like my second career. So Amnesty International brought me to Chicago. I was a Ralph J. Bunche Fellow for 2 years. If you know anything about Ralph J. Bunche, he was, I have something on him, the Nobel Peace Prize winning diplomat in civil rights advocacy, which is what actually brought me to Chicago. And I was working on that at Amnesty. From there, I went into a couple of firms and realized, I think I'd like to do something different. Should I stop there?
Keep
going? Okay. And then I decided, let's go back and realize and understand what I really, really want to do. And so I realized, wow, I'm really good at contracts and commercial law. Why don't I do that? But I really wanted to blend my human rights side because I had spent quite a bit of time doing
Sure.
that. But I also wanted to keep working. So now, well, the loans kind of kicked into for law school, truth be told.
Oh, yeah.
So I needed to keep working, but there was no program that was an international law that was based on humanitarian law. But John Marshall said, "Why don't you come in and talk to the dean?" We had a series of meetings, and they said, "Look, Demetrius, it's businesses that makes the world go round. It's businesses that control the humanitarian efforts," which was not what I had been thinking. And so I
Uh-huh.
enrolled in this international business and trade program to get an LLM, which is a master's in law, and realized this is pretty much true. I mean, now I see, being a part of the Illinois DEC and a commissioner, that there really has to be a combination, there has to be a collaboration between governments and private entities. But at that time, I was really focusing on private entities and how they do cross-border transactions, which had quite a bit to, to do with governments as well. And so I finished that. I
So
thought
we
I
have to
would,
move on.
huh?
We have to move on to the next questions.
Oh,
This
question, this
was
question, going fast. Okay,
60 seconds times 5. Okay.
okay.
I could listen to what you're doing all day long because it's so darn interesting.
It was
Okay.
a segue.
In one sentence then, because we're going to make up for lost time, in what sentence what do you best like about what you do?
Well, there's a lot of things that I like about what I do, but I like it when businesses are not yet global, and then I can be the architect and kind of lead them to that global sweet spot.
Okay, fantastic. And the flip side of that question is, what do you like the least about what you do?
I do not like it when businesses have losses that could have been prevented.
Okay. If they had just come to you first. Right. Okay.
Yeah.
Hindsight is 2020, as they say.
Yes.
All right.
Yeah.
So let's get into the meat and potatoes here. I have a lot of questions. I don't even know if we'll get through all of them, but we will
I
do
know
our
you did
best.
send me a lot of questions, Anita.
I know, right? Okay. And we're going to keep these to like a maximum of 2 minutes each. So if
Okay.
I want to be able to get to as many as possible. So if I do interrupt you, please, please, please forgive me. But
Okay.
I want everybody to get a sampling of everything we wanted to talk about. So
Okay.
a week or so ago, I started off one of my LinkedIn posts for the forum by saying there's never a problem till there's a problem. So I think a good general question to start with would be, how can a well-written contract actually prevent disputes before they arise?
Okay, I wrote this one out. Okay, so a well-written contract is going to clarify all of the roles and the expectations, as well as the deliverables, and very important, the timelines. Also, what I find that people may not stick to, but what is very important is what happens when it doesn't go right, when there is the dispute, how is it handled? When it's tailored exactly to international law, it goes much better.
Okay, fantastic. Now, if something does go wrong, how does
Mhm.
a well-constructed contract help resolve things more smoothly, let's say?
Well, it's going to actually say, it's presupposing what is going to happen at that point and what those actual timelines are. So whether that be arbitration, which I think is better than litigation, but it can turn to litigation. It's like this roadmap that will, presuppose all the issues. And then no one is feeling like ambiguous about, what was supposed to happen in that situation. So it's going to protect the relationships, preserve options, and often, which is really one of the things that I look for down the road, making sure it's kept out of court.
Okay, yeah, that's a good thing. So we're going to talk about both importers and exporters, but first part of this question is, what are some examples of the types of contracts that importers might be asked to sign or ask others to sign? So in other words, specific to importers.
For importers, we are looking, well, for both, we're looking at joint venture agreements, right? So for deeper partnerships and all of the risks and the returns and all of that is going to come under the joint venture. Then sales contracts are for all of them, setting out the terms for each of the transactions, including the delivery, the risk, and the payment. and then IP licensing agreements for both parties, either way.
Okay. And then is there anything more that would be specific to exporters?
When I'm looking at the exporter contracts, there's a lot of distributorship agreements that come up, and they outline the exclusivity or the non-exclusivity, which is the right to sell a product. And it always comes up, what exactly is the jurisdictional boundary, and can someone else pick it up if it wasn't specifically spelled out in the contract? I also find that agency becomes important in these exporter agreements, and often when you're hiring local people, and which is like the sales reps, excuse me, um, they want to assume some type of ownership, and then if that's not spelled out clearly, that becomes a source of confusion as well.
So what does agency mean specifically with regard to what you're talking about?
It means that I'm giving you the authority to sell something on my behalf. And
Mhm.
so once you have the authority, you're sort of clothed with the ability to use all the IP, and you can talk as if you're me. But it gets skewed when you really are talking as me, but the things that you were supposed to come back to me for and clarify, you didn't, because you thought you were clothed with this, like, godlike authority.
Oh, okay. Ooh, that sounds dangerous. Okay. You have worked with a wide range of clients across borders around the world. What are some of the biggest misconceptions that you find that people have about international contracts?
Mm. One of the biggest ones is that, well, it used to not be chat. It used to just be, I can find these contracts or get these contracts from someone else who has used them. And there is no one contract that fits all. They all have to be tweaked. And now that we are using AI, I think I have to, put a triple exclamation there, because um, chat will give you the incorrect law, um, the incorrect cases, and make it sound so beautiful, tie it up with a bow, and it's all wrong.
Mm. So we hear that in so many different industries, like do not rely on AI to write things for you. It's great for research, but then you still have to check the research, like, trust but verify, right?
Yes, can I
Um,
share one quick little tidbit here? I was at the networking that Doug was mentioning, and someone was saying, well, he was actually arguing the other side of it. He was saying that I do not think that, you should use chat for any type of contract or this issue. And I was thinking, well, there are some times when you do want to start with an outline using chat, and then I said, well, let's try it. Pulled out my phone, and he gave me this, scenario, and I put it in chat, and chat said, you should seek an international business lawyer. And I was like, I guess I'm wrong.
give the
Chat got it
card to
right.
AI, they could just disseminate it for you. That would
Yeah.
be great.
Yes.
Okay, so you're sort of alluding this. I call this the elephant in the room. We know
Mm,
that there are boilerplate contracts out there, and you
yes.
said every contract needs to be tweaked, but why specifically is that not the way to go? What's missing from these one size fits all templates?
Oh, I have so many examples. So one of the examples of an international contract, there was the contract, and then there was the translation of the contract. And they were operating as if they were the same thing. And I didn't speak the second language, and so I was sort of relying on the other party to say, paragraph 2 is the same as paragraph 2 in this contract. And it turns out then, at some point I was like, no, we need to hire a translator so I can make sure that we're talking about apples and apples, oranges and oranges. And it turned out that we were not. It turned out that there were two different contracts. So that's one, because that just took me a long time to work through. It's one of the things that I cautioned people about. What was the other part of your question, Anita?
Like what's missing from the one size fits all templates?
Oh, um, well, local laws change a lot, and so you might get a contract that your vendor was using with someone else, a week ago, a month ago, and it's already changed by the time you're using it. And then, with especially with Illinois law or with local laws in the U.S., you may be going, from the UCC to, the international contract law, and it's not in the contract. So I just think that if you're not thinking through every scenario, you don't know what clauses should go in there.
Right. And UCC, that refers to the Uniform Commercial Code.
Yes, which is, particular to the US. But also,
Right.
on the international stage, you also have the CISG, and then you have other local laws that are in that jurisdiction that, if you grab a contract from, India, but you're really in a Middle Eastern country, then it's not going to have the local law in there.
And what does CISG stand for?
That is the UN Convention on Contracts for the International Sale of Goods, which once you
Okay.
cross country lines, you're automatically, it's a default. And so if you don't want to be in it, then you have to say, I'd like, to go under a certain law. But people don't always pick up that detail of it,
Okay.
of the pre-printed contracts.
Got it. And so we in the US have the UCC, which covers all
Mhm.
50 states and territories, I'm assuming.
Yes.
Does the EU have something similar either for the European community as a whole, or do individual countries within the EU, for example, have their own equivalent of the UCC or AUCC?
Um, I have not run into that. Usually, when I'm dealing with Europe, everyone is fine to default into the UN convention,
Okay.
which I think it's more predictable. So I like it.
Okay,
So I
good. Yeah,
recommend it.
that makes perfect sense. Okay, so now what about when people try and wing it themselves? What are some of the common mistakes that businesses make when they're drafting their own contracts for international trade?
I don't think that they clarify things enough. A lot of times, if businesses are doing it themselves, they're really new to trade, because I mean, definitely at middle market, you will have a lawyer that is in house, and so you would be, taking that through your legal department, and you wouldn't be doing it. So it's smaller importers and exporters, and they may not have the full descriptions of the parties, of the expectations of the deliverables, and when it's not spelled out, it's a recipe for confusion. And so a lot of times when I come in, like after an issue, a lot of times lawyers aren't called until there's already a problem. So by the time I
Yeah.
get in, then I have to go back and really figure out what exactly was the agreement.
Okay, that makes sense. Um, so trying to do it yourself is definitely a novice move, right?
I do not
To be
recommend it.
kind.
I do recommend looking at contracts that are pre-printed to get you started, to know exactly what you should be thinking about, but
Mhm.
not to sign it and think that just because you found it on a specific site that it's going to work for your situation.
Is there any clause which, if not included, would pretty much deem a contract unenforceable?
Oh yeah, there are a lot of clauses, especially like in Sharia law. If you have anything in there that is dealing with interest, it's not going to work in that country. So you hope that nothing went wrong if you do sign a contract without looking at the local laws. And sometimes, like,
Interesting.
even I don't know all the local laws, right? So I may have to either retain or consult with local counsel to make sure there aren't things that are changing that I'm not aware of. So you can definitely see, like, an international exporter who's just starting out, they don't have the time to do that kind of research.
Okay, that's interesting. They hadn't thought about that's interesting. Okay. So, what about when someone's being asked to sign a contract? Are there any red flags in contract language that business owners should spot on their own even before bringing in legal help?
Um, I don't think I would have this would have been on my radar until COVID happened. So looking at, force majeure contracts or clauses, they were force majeure contract or clauses were always pretty boilerplate. And then
Uh-huh.
after COVID, the courts started saying things like, well, you didn't have in this contract that that this would be voidable if there was, some disease that, was around the world. And I was just like,
Yes.
what? Like how could you be thinking about that and have it explicitly in a contract? But it did, turn on some light bulbs for me where I said it's more of diligence, more due diligence than originally I think anyone had ever thought of. And so now we're looking at any possibilities, which you have to know in our cyber world right now. A lot of it is around cybersecurity and making sure that those clauses are in there. You're not even going to consider it if those aren't in there.
Okay. And this, I'm going to jump ahead to one of our other questions. We were going to talk about force majeure. And for those that don't know, it's a very fancy and very French way of saying unforeseeable circumstances that prevent someone from fulfilling a contract. So, in keeping with there's never a problem to there's a problem theme, what clauses do you recommend that people put in their contracts to protect them from unexpected disruptions, such as the force majeure contract clause?
Well, it's usually the force majeure clause is there. It's just that all of the different scenarios that could affect the contract or the sale, the cross-border sale, they're not contemplated. So there it might be things like natural disasters, war, pandemics, civil unrest, political upheaval, governmental embargoes, cyber attacks, or as we are seeing right now, sudden regulatory changes. So if those are not in there, or something that's close to that, they're just like a red herring. I would highlight it and make sure that even if that paragraph that used to be a, maybe four sentences, even if it turns into 2 pages, I think it's worth doing it
So it's always evolving because things that do you ever argue what is or isn't considered force majeure? Like what
all the
maybe
time.
for one person, like the laws change somewhere in the world, let's say the United States, and someone else says that's not our problem. It shouldn't, it had nothing to do with our agreement. We don't consider that force majeure. Like, does that become something you actually have to argue as well? The
All the
definition?
time. Absolutely. Absolutely. And then, sometimes you have to go outside of the four corners of that contract and look at, emails and texts and maybe some oral representation of exactly what was being contemplated. But by the time you do that, you're pretty much in litigation.
Oh my God, that's painful. Okay.
Cha-ching.
What are the key elements of a solid international trade contract, regardless of the country or jurisdiction? I mean, can you even like generalize about something like that?
Um, who, what, when, where, how. Those are always important to have in there. Um, I guess now, besides the parties, besides the time, the place, the deliverables, I am making sure that technology integration is included. Um, and whatever platforms that people will be using, and how the IP will get disseminated, those have turned
Mhm.
out to be very important.
Okay, interesting. Let's see. When working across jurisdictions in cross-border trade, what should
Mhm.
businesses keep in mind when choosing the governing law or dispute resolution venue?
Well, you want to choose jurisdictions that are enforceable and at least neutral, if not favorable to your side. That's a lot of what lawyers are always doing to try to find the most favorable jurisdiction for you. You definitely don't want to have to litigate in a country that will not enforce a foreign judgment. You want to consider, and this is, I think this is in all of our contracts. I could think of a few where people didn't want them, but
Mhm.
making sure that you have named arbitration centers like ICC or wherever it is, that it's on neutral ground, and you are deciding very early even what laws they will apply. Because if you're in, if it depends on where the problem happens, right? So if the problem happens in country A, then their laws will apply if you haven't said something different in the contract, and that law may not be either it may not be favorable to your side, so you want to try to deal with those issues right up front.
So can you actually choose a jurisdiction that has nothing to do with either where the product is coming from or going to?
It's going to depend on what if you're inside the US and you are using the UN convention, then yes. But in other situations, if you have opted out, then no.
So whatever jurisdiction you choose, you have to have confidence that not only will they be favorable and the contract is still enforceable using that jurisdiction, but that they're familiar with the laws that would affect the whatever
Whatever
that
the
trade
problem is,
transaction is.
whatever the problem is. So it's a presupposing, and then it's a research based on what you are thinking could possibly happen, to see if the laws of that jurisdiction, for usually someone knows what jurisdiction they want to be in, and New York is always a kind of a safe place for everyone. But and that's because they will apply the law that's in the contract without question, but some
Mhm.
jurisdictions will not. And if especially if it's not spelled out. Like it might
So with
say, we're going to use local law. And for some jurisdictions, that's just not good enough. You have to say exactly what that local law is for whichever problem. The goods didn't arrive. There was an IP protection issue. There's an agency issue, and the jurisdictions may have different laws for each of those. So you may have two or three laws and jurisdictional laws that you want to apply in the contract.
so so like within the US, then like for example, how many different jurisdictions are there to choose from?
Well, every state is a different jurisdiction.
So even if you're not in New York, like, and you're not in New York, and you're not incorporated in New York, your offices are not in New York, nothing's
Yes,
happening in New York,
right.
you're in California. You could
Yes,
still choose New York as the
yes,
jurisdiction
yes. You can
because it's
you
in the
can choose.
US.
Yes, because it's international. You can choose New York, and then you can choose what laws are applied there. Now we're talking about in arbitration, the courts are still going to do their own balancing tests. So the courts may decide that you got the whole contract wrong. But you've already thought about that when you decided to go there.
Okay. I mean, you could choose Tennessee if you wanted. You could choose Michigan if you wanted, right? Like,
Yeah, I mean, some of those jurisdictions are going to want to know that there is some connection to their jurisdiction. So it may just be that, a truck came through there or something like that. But you will have to have, in those jurisdictions that are not necessarily the most global of jurisdictions, you want to make sure that there's a sufficient cause of action that can occur there, or that has occurred there.
so it could basically be anywhere along the line. Like, let's say you're getting something from the Canary Islands, but they have to send it up to like Barcelona for some reason, and then it comes, I don't know, maybe it stops in New York, and then I don't know, like it touches a bunch of different places.
Right.
So you could, in theory, pick any of those jurisdictions along the line because you know that that product is going to touch something along the way in that trajectory.
Yeah, I mean, you could, and you could do arbitration there, right? But if you decide, or well, usually if you're choosing arbitration, then it's not going to go through the courts. But let's say you don't choose arbitration and you just say, okay, we're going to litigate there, then that local jurisdiction is going to decide if this is actually the best place to have that contract dispute decided. Now, they will look at what the parties have already decided inside the contract, but they will do their own balancing to see if they are the correct jurisdiction.
So they could actually reject it and send you somewhere else, and you'd
They
have
can
no
reject.
choice on where that other place is?
They're going to send you to, some place that's more in line with. I mean, they're not going to tell you where to go, right? You're going to have to find the next jurisdiction. They're just going to dismiss it, and they're going to say we
Got it.
don't have jurisdiction for this.
Okay. Oh, that's interesting. Okay. So, you alluded to this, but what's your view on arbitration versus litigation in cross-border disputes? Is one generally more favorable to small to medium-sized companies, or is it across the board?
No, I hands down, especially when you're litigating in the U.S., we have such a vast um, array of discovery procedures. So we have depositions, and they're usually for 4 hours, but you can ask for more time, and if there's more questions, you can get more time with every single person that might be involved in the litigation. So you can see just there, getting schedules together, you could be doing that for a year. And then you have interrogatories where everyone has to answer questions, and then there's motions to compel if you don't answer. I mean, I'm just giving you some of it, but discovery in the US can go. I met someone in court, and they were on a case that had been going for 25 years because of discovery. And I'd never heard of that, and I was just like, "How can you be working on this for 25 years?" But they were like the third, the fourth, the fifth lawyer or something like that, but the discovery just kept going. So hands down, arbitration is, I think, the best way to go. The other thing that I like about arbitration, not just that they don't have all of the leeway for, kind of extended discovery, but you don't have to be a lawyer to be the arbiter. So both parties can decide. Say it's I don't. It has something to do with food. You could actually have someone who is an expert in transportation of food, and they could be one of the arbiters if the parties agree. And so sometimes you'll have like one party will get to choose an arbiter, and then the other party will get to choose their arbiter, and then the third one they have to choose together. So I just think it makes it neutral, and then I love the fact that you can bring in experts because lawyers know law, but business people know how this is supposed to go and what usually happens in this trade or in this industry in a way that judges and lawyers don't necessarily know.
Interesting. My question is, how can anybody afford to be in litigation for 25 years? That's insane. So insane. Anyways, next question. Moving on, as they say. How can importers and exporters account for issues like currency fluctuations, shipping delays, or political instability in the contracts?
Well, of course that's going to be a force majeure. You can put it in there. You can build in currency adjustment clauses as well as shipping delay allowances and political risk contingencies. And when you use these, they're like hedging. They're hedging for the currency, and you can also consider political risk insurance. Actually, you can insure. Like I suggest that you insure for anything and everything that you possibly can, especially if you're entering into emerging markets. And then I always think that it's important to do backup supplier provisions to address any kind of delays or instabilities.
Okay. Okay, that's interesting. And we have had commercial insurance, trade insurance expert on the Export Import Forum before. You can go back and find that. It was Monica Vadas. You guys
Okay.
can find that on the what's it called? YouTube, on the
You
Global
too.
Chambers YouTube channel. Okay, let's see. What should businesses be doing right now to audit or upgrade their existing contracts?
I think that they should be looking over all of their agreements for the last 24 months, making sure that they are country compliant, making sure that those agreements have the correct Incoterms in them, and that you have governing law clauses. And if you have contracts where you did not consider arbitration, and I mean specific arbitration, like not just we will arbitrate, but where we will arbitrate and what we agree will come into the arbitration, as well as the force majeure. I think you can go back and you can change those. You can bring in legal counsel in whatever jurisdiction that is to look at those local laws, to do the research on those laws, and basically just a legal checkup. And just doing those can save your business, thousands of dollars.
That's interesting. Okay, I'm going to give you one more question and then I want to open it up. I have more, but I want to give other people a chance. So, if someone's just getting into import export, what's the
Mm.
single most important legal tip you'd want them to take away from our conversation today?
Make sure you have a good contract, but I also think it's super important to make sure that there's an import export plan, because a lot of people, for good reasons, and one of the reasons that I'm in is because international law and trade is so exciting, but if you don't have a fully thought out plan, you can go awry, or anything can go wrong
It's kind of
and
scary,
wind up with
actually.
25 years of litigation, which is like the worst case scenario I've ever seen.
Yeah, that's horrifying. Honestly, I think I'm going to have nightmares tonight.
Sorry. I had a
Anyway,
nightmare after that.
yeah, yeah. So we have about another 10 minutes or so, a little bit more. I do have another question for you, but I want to see everybody can take themselves off mute if they like. And there we have it. If you have a question, Jim knows how to raise his virtual hand. If you don't, you hit Alt Y. If your particular version of Zoom doesn't have the icon for it, but Alt Y always raises a hand. So, Jim, what's your question?
Demetrius, always educational. I'm going to put two questions and hang up. Are you involved, or your clients come to you as a broad brush with the MOIs and MOUs, or do you have to teach them how to get to before the contracts get there? Number two, if a contract has to change, do you handle like a codicil in a will or something without redoing the entire contract?
Well, let me take the second one first. So, built into the contract, it should say how we will deal with the problem where we need to change the contract or where we need to amend. So, again, that's going to depend on the contract. If you don't have that in there, then my suggestion is that you're doing a totally different contract, because if you try to just have the addendum at the end or a codicil at the end and then it does go to litigation, the court is not going to the courts are not going to adhere to what you're trying to do later, and they're going to go with the first contract. And then okay, so I jumped right into it. Will you repeat your first one, your first question?
Well, do they come to you with MOUs and MOI or MOIs and MOUs in the process? Do you teach them how to use it before they get to you on a contract basis?
It varies. I would say it's about 50-50. I love it when they do come with them, or when I do get an opportunity to teach on it. MOUs, like letters of intent, because then I can always do the research up front. So everyone, I mean, I think it's the meeting of the minds, right? It's making sure that we are really clear from the beginning. But a lot of times that other 50%, we are already in the middle of a problem. It's already happening, and we have to jump in and decide, you know, how we'd like to strategically deal with the problem. So, but by the time you say it's a problem, it's already too late to go back and do that. It's rare. I think about contracts in business, including international trade. Just like a marriage. When everything is courting and everyone is nice and smiling, the food's good, it's easy to talk about the problems. You just try to figure them out up front. But when it goes wrong, it's emotional, and you're getting witnesses together and everyone remembers from different perspectives. And so it just makes it much more difficult. So I like what you said. I think I wish that everyone came to me beforehand, um, and then we could go through the memorandums of understanding, and it makes it go smoothly. And I
Awesome.
know dealing with
Okay.
startups, I know I'm thinking that you asked that question because you are making sure that people know about them. Is that right?
Absolutely.
Yeah,
All
absolutely.
right. It just makes everything faster and smoothing the entire journey if you do your homework before it gets to be a problem.
I
I'm done.
agree.
Good
I agree.
idea. Yeah.
It's what I'm
Okay.
teaching my 13-year-old too.
Lesson basically.
Right.
Yeah.
Do your homework
Yeah.
up front. Do it on the front end because it's much worse on the back end.
Good luck with a
Yeah.
13-year-old with 7
Oh,
grandkids.
I need it.
My
I
goodness.
need
Okay. Dave, you have a question?
Sure. When you're going into a country perhaps that you've never dealt with before, how do you find and vet and choose local counsel?
Oh, well, I'm a member of the American Bar Association and several other bar associations, so I'm using my contact that way. But I use the Global Chamber a lot. I try not to use them for every contract, but if it's an issue in a locale, in a jurisdiction where I do not have a direct contact, yeah, I reach out to Doug or Cesar or Jim and say, I'm looking for this. And sometimes I don't find a lawyer that's a part of Global Chamber, but I will find someone in business and find out who are they using.
Great,
So
thank you.
we have the global hookup.
Exactly. Thank you.
Very
You're
true.
welcome.
I have another question for you.
Okay.
Are there any cultural or legal nuances that tend to get overlooked when US companies contract with overseas partners?
Um, Let me think some. The one that I've run into quite a bit is the interest. Having something in the contract that deals with interest, and a lot of the Arab countries, it's voidable if there is anything about interest. So that's one that I've run into before. And then, I was talking about the dual contract where it had been translated, and then it was like everyone thought we were using one contract, but there were cultural nuances in the one that was translated that weren't in our contract, and they didn't really have a correlation. So so those are the two situations that come to the forefront of my mind.
Okay. And myself being bilingual, I see translation sometimes. I've been in conferences speaking and I've been listening to the translators, and I'm thinking, that is absolutely not how I would have worded that. Uh, it's and scary. So when you're talking about something legal, I mean, it's bad enough when it's just day-to-day conversation or about something that's not life changing. But when you're talking about something that one wrong word can literally make you liable or not, um, I think that would be very scary. So do all the translations for contracts have to be done by certified translators? And even then, there's still just so much wiggle room.
No, no, I've not seen a law on that. But I do think they have to be translated, right? A lot of times that you can't get around translating them. It's just that you don't want, like, once you have the translation, you have to agree to one language. Um, because with this contract that I was talking about, what they tried to do, when I came in and had that objection, is put it side by side. Like, this is this is one language, but it still didn't work because I guess what you have to think about is, in the event that it goes to arbitration or it goes to a judge, is a judge going to be able to figure it out? And that judge, most likely, I mean, I hope they're bilingual like you, Anita, but most likely they're going to speak one language and they only want to go forward on one language. And so all the proceedings are going to be conducted in that one language. If it is arbitration, you can make a decision which language that is. But if you've already chosen the jurisdiction, which is another reason to be careful about which jurisdiction you choose, then they are going to go by the language of that jurisdiction.
Okay, yeah, because even if you go by the translation is still coming off of the original one. It's just a matter of their interpretation or their choice of words, which could be correct or incorrect or not transmit the intent of what was meant
One
to
of
be
the things
said.
that was, Anita, one of the things that was in this translation was, and when they translated the number, so there was something that was like $200,000, and then they were putting, and it was cultural. I think it was cultural because I wasn't used to dealing with it, but they were putting like 200.000. So no, for us that was $200, and you just put some extra zeros in there. But and it was the matter of a comma. And then I wanted to tell you this. This is out. This is kind of more governmental. But I was at the United Nations, and I went into one of the contract drafting rooms, and there was a comma that they argued about for 2 days. So, that helped me to realize that when I'm making a big deal about a comma or a period, no, I mean, if we're going to talk about it for an hour and exactly what it means, then we just do that. At least it's not 2 days. But depending on how important the contract is, commas, periods, they change, and I think it's cultural.
Yeah, well, I will tell you that in Spain, because I spent a lot of time there, and I don't know about the rest of the EU, but they use decimal points where we use commas and vice versa. So 200,000, there would be written 200.00 comma, let's say there's 50 cents, comma 50. So they do it the other way. For us, we've been taught, the decimal point is what you do before, when you get into like the dollars and cents. But I don't know if you call it cultural or just like, like they use meters and, they use a metric
But I
system.
think
We use something else.
with this contract, if it had not been translated, I think that would have been okay. If we said we're doing this contract in Spanish, right? Then that would make sense. But we had already translated it, and then the numbers were still reflecting the other jurisdiction. So it didn't work.
It's confusing. Yeah, no, I get that. It's kind of weird when you look at it for the first time, but anyways, so we are getting close to the close. So, Dave, do you have a final question? It's got to be really quick. Or is your hand still up from before?
No, new question. So you're a member of the Illinois bar, but can you represent companies around in all 50 states, or how does that work?
Well, usually, like right now, I'm applying for Pro Hoc Vice. So Pro Hoc Vice means if I have local counsel, then I come in kind of as specialized counsel in whatever jurisdiction it's in. And sometimes we just associate with another lawyer in that jurisdiction, and we hire that lawyer there. And then they will just keep me abreast of what's happening, or we'll talk back and forth about what is the best strategy.
Great, thanks. Do you have one in Arizona? If not, I know a good person to refer you to should you need it.
Yes, no, I don't. Please
Okay,
let
great.
me know, because I do Pro Hoc Vice quite a bit, and when I already have someone, it's relatively easy. You're just asking the court, I'm in good standing in my jurisdiction, they're in good standing, they will kind of vouch that I'm in good standing, and then the court will allow me to practice in their jurisdiction. So yes, I'd love to have that contact. Thank you.
Okay, we'll connect. Perfect.
Awesome, awesome, awesome. Okay, my cat Raider is making his required appearance. Sorry about that. Anyway, so Want to thank everybody for joining us today for this month's Global Chamber Export Import Forum. And thank you, Demetrius, so much. Like literally this stuff, I'm nerding out on it. I'm having so much fun. I could just do this for hours on end. If you all enjoyed today's session, then I hope you'll join us next month. We're going to tackle a very interesting subject as well. Casey Branch, who's also an attorney, will be my interviewee, and we're going to talk about exporting expertise and technology in the cannabis arena. You obviously cannot export the product, but the brain power behind CBD and other things can absolutely be exported and imported. So we'll be talking about that. In the meantime, be sure to check out the calendar for the Global Chamber. If you ever can't sleep or you're bored, there's something going on somewhere in the world. The time zones, they just, they never stop going. So you never need to eat dinner alone or whatever. You've got somebody to talk to. So make sure you check that out. And just remember that being global is actually a great thing to be. So join us next month. Have a good Labor Day weekend in the meantime. Don't forget to save the chat, and we'll see you soon.
Thank you. Thank you, everyone, for your great questions. Look forward to connecting.
Thank you.
Bye.